Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Perseverance is a really good character trait to have. Stick to it, stay in the fight, get the job done. Usually that's a good trait in litigation, but sometimes it's not a good trait, and it's particularly not a good trait when you're dealing with a situation where you just don't have a case. We're going to talk about that today down at the beach. This is the sad tale of Ms. Scanlon, who brought a lawsuit against the Greenwich, Connecticut Police Department. Now, the background will unfold here in a minute when we look at the opinion, but the bottom line is that when the Greenwich Police Department did an investigation, they could not substantiate a cause, basically a criminal act that would have resulted in an arrest. When they took the investigation to the state's attorney said, we're not going forward with this. We're not issuing an arrest warrant on this. And as a result of that, she got pretty annoyed and decided that she would hire attorneys and sue. So she hired attorneys and sued, and the mess that follows is what happened. So here is the opinion. This is by Carrie A. Dooley, United States District Judge. This civil rights action arises out of an investigation into an assault complaint made by plaintiff Paula Scanlon, which was conducted by Sergeant Detective Reeves and Detective Rondini collectively, both officers of the Greenwich Police Department. The town of Greenwich is also named as a defendant under a Monell theory of liability. After 4 years of extensive discovery and very contentious litigation, which consisted of 36 depositions, dozens of interrogatives, thousands of pages of disclosed materials, and robust motions practice, the court granted defendants' motion for summary judgment and denied plaintiff's cross motion for summary judgment as moot. Judgment accordingly was entered in favor of defendants and against plaintiff. Defendants now move for an award of attorney's fees and costs pursuant to Section 1988 in the amount of $902,469.56, to which plaintiff has objected. For the reasons that follow, defendants' motion for attorney's fees and costs is granted in part, and defendants are awarded $239,857.50 in attorney's fees and $9,678.81 in costs. So the court goes through the standard of review, and it basically says, look, you can't grant fees to a defendant just because the plaintiff lost. There has to be something else, that it has to be basically a frivolous claim. The determination as to whether a claim was frivolous, unreasonable, or groundless is also ordinarily reviewed not for clear error, but rather for abuse of discretion, and requires an evaluation of the allegations and the proof in light of the controlling principles of substantive law. A claim is frivolous where it lacks an arguable basis in either law or in fact. So here are the facts and procedural history. In July 2016, plaintiff reported to her school counselor that she was assaulted during a June 3, 2016 pool party at her house. That same day, Detective Rondini received a report from the Department of Children and Families regarding her assault. The plaintiff was a high school student at Greenwich Academy, an all-girl preparatory school, and she identified her attacker as a student at Brunswick School, a nearby all-male preparatory school. So you have one group of preppies suing another group of preppies. Over the course of the summer and the fall of 2016, the Greenwich Police Department investigated the complaint. At the conclusion, they submitted a 21-page arrest warrant application for the alleged assailant to the state's attorney's office. In January of 2017, the assistant state's attorney, John Capozzi, determined the application lacked probable cause and did not present it to a judge of the Superior Court. Plaintiff's counsel and her parents secured a meeting with then state's attorney Richard Coangelo regarding the application, in which they were advised that the case would not be prosecuted because of the inconsistencies in plaintiff's statements. So then in August of 2018, the plaintiffs sued, and they made four claims. violation of 14th Amendment equal protection, violation of substantive due process, intentional infliction of emotional distress, and negligent infliction of emotional distress. So they filed a motion to dismiss, the city did, and the only claim that that basically went forward was the equal protection claim that basically the police department had a policy where it would collude with Brunswick School in an effort to shield students from prosecution when a Brunswick student was identified as the perpetrator of a crime. Accordingly, plaintiff alleged this policy resulted in disparate treatment of crime victims, including herself, depending on who was alleged to be the perpetrator. On December 6, 2019, as discovery progressed, counsel for defendants sent a letter to counsel for plaintiff setting forth the lack of evidence supporting plaintiff's claims and offered to recommend to their clients a mutual walkaway. In exchange for plaintiff withdrawing her claims, defendant would drop their claims for attorney's fees, vexatious litigation, and defamation of the individual defendants. The letter specifically called into question the de minimis evidence uncovered to support plaintiff's claim, which at that time included that retired Greenwich police officers worked at Brunswick School's security department, unsubstantiated rumors of a, quote, cozy relationship between the Greenwich Police Department and Brunswick School, the alleged passing of information from Brunswick headmaster Sergeant Reeves, and for an alleged sexual assault in 2014 that Greenwich Police Department had addressed in comments to the press, but which ultimately was not fully investigated or prosecuted because the victim informed the police the encounter was consensual. Defendants requested plaintiff withdraw her claims in light of this dearth of evidence, and the plaintiff rejected the offer that same day. Okay, so at some point, the way the system works is you first go in and you make your claims. There's a motion to dismiss stage, and if you don't state all of the elements, well, at some point the case is dismissed, which is a good thing. You don't want any frivolous claims going forward. Well, that's what happened. And so now the next phase, since there is one claim remaining, the next claim is, what's the discovery going to be like? Let's produce all the documents. Let's, do all the depositions that we need to do so that we can find out exactly what goes into making these claims. And that's what happens. And at the end of it, there just isn't anything there. So let's see what the judge says. So after summary judgment was filed, it was ruled on by the court, and the court said, upon review of the voluminous evidentiary material amassed over 2 years of discovery, there is no genuine issue of material fact as to the existence of an implied policy of protecting Brunswick School students from prosecution at the expense of their victims, or that defendants acted in accordance therewith. Insufficient evidence of any such policy has been unearthed so as to create a triable issue of fact. To hold otherwise would require wholly unsupported conjecture and speculation, which is insufficient to withstand summary judgment. So judgment was entered, and then at that point, the city filed a motion for its attorney's fees. And they said the plaintiff's lawsuit was frivolous from the beginning because her allegations of collusion were based not on facts but on her subjective and cynical beliefs. And then after 4 years of discovery, plaintiff's case was reduced to unsubstantiated gossip. In response, plaintiff argues that there's no basis to award attorney's fees because the case presented a novel legal issue. Now here we need to drop down and look at the footnote because this tells you a little bit about what the court was thinking. As to this first argument, plaintiff contends that because no court has ruled on the application of Myers versus County of Orange to an implied policy evidenced by custom or practice rather than an express policy, as was at issue in Myers, her interpretation, even though it varied from the court's interpretation, should not be considered frivolous because there is little guidance for bringing such a claim in case law. The foundation of this argument is unsound. The second amended complaint alleges an express policy of collusion in addition to a practice or custom. It was this allegation that brought her claim within the scope of Myers at the motion to dismiss stage. When all parties agreed that discovery revealed no evidence of an express policy, defendants argued in their summary judgment submission that Myers should not be extended to implied policies. However, the court did not reach that legal issue when deciding defendants' motion for summary judgment. Accordingly, the court has offered no interpretation of Myers at odds with plaintiff. Indeed, in reaching the merits of the summary judgment motion, the court accepted, for purposes of the motion, the availability of the theory she advanced. Plaintiff's argument that she relied on a novel legal theory in bringing her case does not, therefore, counsel against an award for attorney's fees and costs. So the court goes into the reasons for the fee provision. It's there to dissuade people from making frivolous claims. And then she goes through all of the case law that says, look, you got to be really careful about how you do this. Unsuccessful conspiracy claims are not unreasonable merely because they were based principally or even entirely on circumstantial evidence. And that's because they're difficult to prove under any set of circumstances. So the court then goes on down and says, as discussed above, a prevailing defendant may still be awarded fees when a plaintiff continued to litigate a case after it clearly became frivolous. In determining whether an action has become frivolous, courts generally consider three factors. So after summary judgment was filed, it was ruled on by the court, and the court said, upon review of the voluminous evidentiary material amassed over 2 years of discovery, there is no genuine issue of material fact as to the existence of an implied policy of protecting Brunswick school students from prosecution at the expense of their victims, or that defendants acted in accordance therewith. Insufficient evidence of any such policy has been unearthed so as to create a triable issue of fact. To hold otherwise would require wholly unsupported conjecture and speculation, which is insufficient to withstand summary judgment. So judgment was entered, and then at that point, the city filed a motion for its attorney's fees. And they said the plaintiff's lawsuit was frivolous from the beginning because her allegations of collusion were based not on facts but on her subjective and cynical beliefs. And then after 4 years of discovery, plaintiff's case was reduced to unsubstantiated gossip. In response, plaintiff argues that there's no basis to award attorney's fees because the case presented a novel legal issue. Now here we need to drop down and look at the footnote because this tells you a little bit about what the court was thinking. As to this first argument, plaintiff contends that because no court has ruled on the application of Myers versus County of Orange to an implied policy evidenced by custom or practice rather than an express policy, as was at issue in Myers, her interpretation, even though it varied from the court's interpretation, should not be considered frivolous because there is little guidance for bringing such a claim in case law. The foundation of this argument is unsound. The second amended complaint alleges an express policy of collusion in addition to a practice or custom. It was this allegation that brought her claim within the scope of Myers at the motion to dismiss stage. When all parties agreed that discovery revealed no evidence of an express policy, defendants argued in their summary judgment submission that Myers should not be extended to implied policies. However, the court did not reach that legal issue when deciding defendants' motion for summary judgment. Accordingly, the court has offered no interpretation of Myers at odds with plaintiff. Indeed, in reaching the merits of the summary judgment motion, the court accepted, for purposes of the motion, the availability of the theory she advanced. Plaintiff's argument that she relied on a novel legal theory in bringing her case does not, therefore, counsel against an award for attorney's fees and costs. So the court goes into the reasons for the fee provision. It's there to dissuade people from making frivolous claims. And then she goes through all of the case law that says, look, you got to be really careful about how you do this. Unsuccessful conspiracy claims are not unreasonable merely because they were based principally or even entirely on circumstantial evidence. And that's because they're difficult to prove under any set of circumstances. So the court then goes on down and says, as discussed above, a prevailing defendant may still be awarded fees when a plaintiff continued to litigate a case after it clearly became frivolous. In determining whether an action has become frivolous, courts generally consider three factors. 1. Whether plaintiff established a prima facie case. 2. Whether the defendant offered to settle. And 3. Whether the trial court dismissed the case prior to held a full-blown trial on the merits. So, as applied here, plaintiff did not establish a prima facie case, and what that means is she didn't establish all of the elements of her claim. So she didn't establish a prima facie case. Defendants did offer to settle with a mutual walkaway, and the case was resolved at summary judgment prior to trial. Accordingly, an award of attorney's fees and costs is warranted. The court next determines the point in time at which plaintiff is tasked with knowing that her case is frivolous and without foundation in fact. So at this point, basically, the court says at the close of discovery, the evidence relied upon by plaintiff in bringing the lawsuit was completely debunked or otherwise revealed to be of little evidentiary value. For example, plaintiff cited to a 2014 assault that the Greenwich police did not fully investigate and was never prosecuted. As the court observed in its summary judgment ruling, the view from 10,000 feet might suggest that a Brunswick school student committed an assault and the Greenwich Police Department did nothing about it. However, after discovery, it was revealed that although the Greenwich Police Department Detective Christy Gerard thought an assault had occurred, the alleged victim and her family maintained that the encounter was consensual and did not want an investigation into the matter, and did not want a criminal complaint filed. Indeed, the discovery revealed the exact opposite of the nefarious inference plaintiff urged. Gerard did not accept the parents' initial assessment that the contact was consensual. She encouraged them to view the video, which they did. When they repeated that no criminal complaint would be made because the contact was consensual, she was sufficiently troubled by what she saw on the video that she reached out to the state's attorney for advice on how to proceed. So even the attenuated evidence of some kind of a policy or custom and practice was very clearly debunked at that stage. So the court says, okay, that's the point after which, once you know discovery is done, that's the point where if you don't back off, if you don't clear this thing up, you're going to get hit with fees. And although she knocked down the fees by a little bit, I think it was, let me see what she says. In calculating attorney's fees, the district court must first determine the lodestar, and here that was determined to be about $250 an hour. Plaintiff does not argue the hourly rate charged is unreasonable. Rather, she takes primary issue with the number of hours dedicated. But basically, the court agrees that they should have done exactly that. Now, the Supreme Court has warned determination of fees should not result in a second major litigation, and the goal isn't to audit, but to do rough justice. Hours that are excessive, redundant, or otherwise unnecessary are to be excluded. And in dealing with such surplusage, the court has discretion to simply deduct a reasonable percentage of the number of hours claimed as a practical means of trimming fat from a fee application. So that's what she did. She knocked off about $17,500 in costs or in fees, and that's where she came up with the total of $239,857.50 in attorney's fees and $9,678.81 in costs. Well, over $200,000, almost $250,000 is a lot of money to pay for being pig-headed. You know, I have taken a case that was close. In other words, I lost the case at trial, but I believed very strongly that we had a good case and that the facts were there. The jury didn't. There's nothing wrong with bringing a case like that where you actually had something that happened that was terrible, and you didn't get the jury to go along with you. What is an abomination is when you get to the point where you're looking at summary judgment and you know you don't have enough to go forward to make it through summary judgment, but you go ahead and try to do that anyway. What you don't want to do is when you get to the close of discovery and you look at all the evidence You look at whether or not a reasonable jury could look at your evidence and decide for you on this issue. And if all you've got is rumor and speculation and conjecture, and well, some people say, well, some people say the earth is flat. That doesn't make the earth flat, right? That's why you go around the world, because the world is round, you know? But just because people say it doesn't make it so. And it kills me that people don't get that in litigation. I had a case probably 6 years ago, and it was a referral from another attorney. And the young lady who was bringing the action was absolutely convinced that she had a completely valid case. But over the course of about 6 months, we became fairly certain that a lot of her evidence was all in her head. And as a result, eventually I withdrew, because I will not represent somebody whose plan is to go in and lie in court. That's not who I am, and that's not who anybody should be. But that was the plan, and I objected, and so I didn't go forward with it. And eventually, the young lady was hit with sanctions as a result. Now, the lawyer wasn't tagged with sanctions, which is a miracle, because that can happen. But she was hit with court costs and fees, and she should have been, because she knew that she didn't have a claim. When you know you don't have a claim, you do the honorable thing and dismiss it. In this case, she had an opportunity to walk away. By the time she got to the point where they had walked away, it was apparent that the county had rung, or the city had rung up, about $700,000 in legal bills. $700,000. And by virtue of running that up, I mean, I would not want to have faced a $700,000 fee claim. And so, at that point, you have to fish or cut bait. And if you don't think you can make it through summary judgment, and you force them into summary judgment, which is the reason it takes so many hours when you do summary judgment in a case like that, is you have to go through all of the evidence, and you have to go through, in this case, very little evidence, but you have to show the evidence that is contrary to the other side, and establish that they don't have a triable issue of fact. And that can run into 200-300 hours of attorney time. And when you do that, you're going to wind up paying for 200 to 300 hours of attorney time. And they just didn't do that. I hope this is one of those cases that people can look at and realize that there are times to fight and there are times to withdraw. Discretion really is the better part of valor in certain instances, and particularly when you're facing a well-funded defendant and they have hired really expensive lawyers and you don't have very much in the way of evidence. You need to listen to your lawyer, and in some cases you need to tell your lawyer, look, this isn't worth getting a fee strike on. Let's let this go. Sad but true. So that's what I have for you today. If you have any questions, please leave them in the comments down below. Thanks to everybody who left a like on this video. Thanks to anybody who subscribed. I appreciate you being here. At some point in today, you may have an opportunity to go out and do something nice for someone. Maybe you'll make a phone call for somebody. Maybe you'll call somebody's boss and tell them, wow, you know what a great job Sally did yesterday. Just do something nice for somebody. Do that for me, will you? I'd greatly appreciate it, and it will make you feel better. Thanks, and have a terrific day. We'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.